Good morning, and thank you all for coming. And thank you especially to Kelly for coming from Minnesota. You provided an enormously helpful framework for everything that's going to come after, for specifically about Michigan. But you've also been a hard act to created a hard act to follow. So not only because of your expertise, but because of your spiffy, sophisticated slides. Now we're going to very few slides in a regular old-fashioned kind of speech, so bear with me. Our purpose in doing this report was twofold. We are hoping to encourage the reestablishment of a sentencing commission when people begin to understand what the need is for it and what the purposes are to be served. And we also wanted to develop data that suggests some of the policy considerations in the areas of research a newly established commission might want to examine. And we thought this research was needed for several reasons. The guidelines aren't the only determinant of how long people sentenced to prison will actually serve. That's impacted by a lot of other factors, like whether people get paroled at their minimum, whether their offenses carry mandatory minimums that are trumped by the guidelines, whether people got multiple sentences that are imposed or run consecutively. And of course, there's the impact of the elimination of any kind of good time or disciplinary credits in this state. Nonetheless, the guidelines play a critical role as the starting point, the minimum amount of time that somebody's going to have to serve if they're incarcerated. And having no commission means that there's been no systematic review of the guidelines as was initially anticipated, as it was meant to be. That the underlying assumptions on which the guidelines were built have never been tested. And there's been no analysis of the data about the actual impact of the guidelines on the legislature's goals in having guidelines in the first place. So, and of course, ad hoc legislative changes have occurred in the meantime. The guidelines were designed in the mid to late 1990s, at the height of the tough on crime era, and attitudes have changed since then. We have much more information about the impact of long sentences and the extent to which that correlates with recidivism. So what we have is a scheme that's been in effect for nearly 25 years and have no idea whether it's meeting the purposes for which the legislature enacted it. So it does seem like it's about time to weigh in and take another look. We chose to focus on the four most common life maximum offenses: murder 2, assault with intent to murder, first-degree criminal sexual conduct, and armed robbery, for several reasons. First, these have the broadest guidelines ranges, so they give the greatest range of discretion to judges. This provides the clearest window on how the guidelines are actually working, how judicial discretion is actually being exercised. These are also the cases where the policy of lengthening sentences for the more serious crimes, these are the cases that policy was designed to affect. And these often involve very long sentences that have the biggest impact on the size and the cost of the prison population, on the people who are serving them, obviously, in the communities from which they come. So our research started in 2013. It began with Elsie Kettinen, who's right over there, who extracted the relevant information from the MDOC's massive database and organized that into data sets, the data sets that underlie this report. And with Justin Smith, who's right over there, who did the initial analysis of the data, reaching ultimately the same basic conclusions we did, but setting up the framework for the more in-depth examination that we did in the later years. We made a lot of progress back in 2013, but life intervened and we stopped pursuing the project temporarily. In 2019, Annie Mahar, who you will hear from next, joined Safe and Just Michigan as a research associate, and that allowed us to get the data analysis back up and running. As a result of this history, our data ends in 2012. And it's true, of course, that things have changed since then. And that may cause different sentencing outcomes. New judges have taken the bench. Prosecutors' charging and bargaining policies may have changed. Public attitudes about incarceration have started to change. So there's no question that a new commission would want to examine the most recent data. But research is inevitably an ongoing process. Every analysis is a product of a point in time. That said, we now have a great deal of data that will not have to be re-examined. We've answered questions that haven't been asked before, and we've laid the groundwork for future analyses. The broad patterns that we discuss in the report undoubtedly continue to be true, even if some details have changed. And much of the report presents information that doesn't change with time. So if you just skim the table of contents to the report, you'll see that we approach the guidelines from multiple angles, ranging from the small amount of previous research that's available to comparisons with other jurisdictions. And the report culminates in a series of recommendations. Some address the fundamental structure of the guidelines and the deeply embedded broad policy choices that underlie them. Other recommendations focus on very specific details of the offense variables and prior record variables. Collectively, they're not only what we believe to be logical responses to the research findings, but they account for the entire context in which Michigan's guidelines evolved and operate. Since not everyone here is familiar with how the guidelines work, I'm going to start with some background information, and I hope that the judges and attorneys among you who are painfully familiar with how they work will bear with me for just a couple of minutes. Initially, the guidelines in Michigan were developed by a Supreme Court committee before the legislature ever stepped in. In 1983, the court set up a committee of judges. They operated for a trial period and then were revised in 1988. The purpose of the judicial guidelines was simply to rein in outliers, those sentences that were way above or way below the norms, and to keep sentences within the averages representing similar crimes and similar defendants. The judicial guidelines were advisory. Judges had to explain their reasons for departing from them, but they weren't required to comply with the recommendations. And they didn't apply to habitual offender sentences. In 1994, the legislature established a sentencing commission to develop guidelines, and those were actually enacted, the commission's guidelines, in 1998. The purpose of the legislative guidelines was normative. That is, the commission wasn't just averaging the sentences the judges already imposed, but were deciding for itself, how much time a particular combination of offense and defendant characteristics should be worth. Compliance was mandatory. Sentences, as Kelly pointed out, had to be, it was one of those states that had to have, where a judge had to have substantial and compelling reasons for departing, either above or below the applicable range. And substantial and compelling meant the reason had to be objective and verifiable. It had to be highly relevant to the purpose of the sentence, and it had to exist only in exceptional cases. And bear that in mind. All our data comes before the Michigan guidelines were made advisory in 2015. So when we talk about departure rates, as I will in a minute, and the idea that departures should be only in exceptional cases, just keep that thought in the back of your mind. The enabling legislation defined the commission's tasks, in large part as Kelly has described them generally, to collect and analyze data, to develop guidelines, to conduct ongoing research about the impact of guidelines, including projected prison impacts. And it was built into the legislation to recommend modifications of the guidelines to the legislature, beginning 2 years after they were enacted and every 2 years thereafter. So obviously, there was this anticipation of an ongoing commission. In addition, the Michigan enabling legislation specifically said that the commission should consider offenses involving violence against a person to be more severe than other offenses. Well, that's generally the norm in sentencing, with the exception of the high point of drug offenses, perhaps. But they didn't say specifically increase sentence lengths for assaultive offenses. They also said establish separable offender statute. This meant that the guidelines, the legislative guidelines, unlike the judicial ones, were to be applied to habitual offender sentences. But they didn't say how different those ranges should be. And as Kelly noted, Michigan, other commissions place some specific priority on certainty in sentencing. That wasn't explicit in the Michigan guidelines, and as we'll see, it didn't happen. Hasn't happened, as many of you know. So the way the guidelines work, what you've got up here in the slide is the A-grid guideline. You'll also find that on the cover of the report. So when that slide eventually comes down, if you want to refer, as I'm talking about various grids, you can just look down at the report and see. We do have 9 grids, more than other jurisdictions. And our grids aren't based on the nature of the offense. They're based on offense, on the maximum penalty for the offense. So person and property crimes, or very different types of person crimes, can end up on the same grid because they have the same statutory max. And they run from a separate grid for second-degree murder. First-degree murder, of course, is mandatory life without parole, so that's not subject to the guidelines. But second-degree murder has its own grid, and the A grid, which is what's up here, applies to life maximum offenses. And then they go all the way down to the H grid, where the max is jail or another community-based sanction. The higher the maximum penalty on the grid, the higher the starting points of the recommended minimum sentence ranges. And we've got the prior record level on the horizontal axis and the offense level on the vertical axis on each grid. And individual prior record and offense variables are scored for the offense. The scores are totaled to reach a prior record level and an offense variable level. And the points required for each level appear in the row and column headings of the grid, as you can see. So you have to have 0 prior record points to be at prior record level A. Just 1 point is enough to increase the low end of the cell going, if you look at it going down, it increases the low end by 6 months as you move from offense level, variable level 1, to by 30 months as you get down to offense level. No, I'm going backwards, sorry. Yeah, no, that's right. To OV level 1. So if you also note on the grid, there's 20 points between each of the OV levels. Bear these in mind as we talk about the scoring of the OVs and how easy it is to get pushed from one offense variable level to the next, offense severity level. Each grid contains a series of cells. Each cell contains a range of months. The A grid has 36 cells. The murder 2 grid, which is not up, has 18. The months in the cell is the range in which the judge is supposed to select the minimum sentence. But as you can see, let's see if I can make this work. You've got on the diagonal the same range of sentences gets repeated. The scoring of the prior record variables, and especially the scoring of the offense variables, requires judicial fact-finding. So, for instance, OV7, which is aggravated physical abuse, has 50 points if the victim was treated with sadism, torture, excessive brutality, or conduct designed to substantially increase the victim's fear and anxiety. The choice for the judge is 50 points or none. And the Michigan Supreme Court has upheld awards of 50 points for racking a shotgun during a carjacking. Also, 50 points for striking robbery victims in the head with an airsoft gun that looked like a sawed-off shotgun. So that alone, without adding any of the other factors, that 50 points would put someone into offense level, in offense level 3. The other offense variables require judges to determine things like the defendant's state of mind, whether the defendant was a leader among co-defendants, whether there was serious psychological injury to a victim's family. These get to be pretty subjective. Judges are also required to calculate the offense variable score on the highest point allocations possible. They can't say, well, you know, he sort of fits, but I'm going to reduce it. I'm going to give somewhat fewer points. The directions say maximum number of points available for any given OV have to be scored. So, as Kelly explained, we're different from other state jurisdictions where the severity level is determined simply by the statutory offense. An armed robbery is an armed robbery regardless of details, unless the statute in another state builds in a detail, like making armed robbery with injury a separate crime, for instance. And that's what the defendant was convicted of. But basically, only the prior record and the nature of the offense as defined by statute determine the guidelines range. So the guidelines range isn't based on any judicial fact finding. Now, judges can find facts that they then use to depart above or below the range, but the guidelines range itself is established simply by those two factors. In Michigan, of course, all this fact-finding is done in the context of figuring out what the guidelines range is going to be, because it's done in calculating the offense variable scores in particular. This difference in judicial fact-finding was critical to the Michigan Supreme Court's decision in 2015 in People versus Lockridge, because that decision ultimately, as I'll talk about just a little bit later, a little bit more, made our guidelines advisory. They had been mandatory, but the U.S. Supreme Court has said that using judicial fact-finding to determine the required minimum sentence violates the right to have a jury decide all facts. So Michigan's scheme that mandated selecting the minimum sentence from cells that were chosen based on judicially found facts violated the Sixth Amendment. The way these cells get utilized is in each cell there's a minimum, and a maximum minimum. So right in this corner cell, 21 months would be the low end of the range, and for someone who is not habitualized, 35 months would be the high end, the maximum minimum. And, you know, Michigan practitioners tend to refer to the min and the max-min. But remember, as Kelly stressed, these are the minimum sentence that's being chosen by the judge here. The maximum sentence is normally the maximum set by statute for the crime. However, for life maximum offenses in Michigan, which has not revised its penal code in decades, remember, the statutory penalty for the offenses we're looking at is life or any term of years. So when the judge doesn't elect a parolable life, and that doesn't happen very often these days, parolable life sentences aren't that common, it is the judge who's selecting the maximum sentence as well as the minimum. So the judge for a life max offense can say 10 to 20, 25 to 40, 60 to 90, whatever they pick. So the length of that range between the minimum and when the defendant would max out, the range within which the parole board has discretion, is whatever the judge decides. The effect of habitualizing, then, compounds the breadth of the ranges. If a prosecutor elects to file an habitual offender enhancement, the max-min, the high end of the guidelines range, is increased by 25, 50, or 100%, depending on whether the defendant is sentenced as a second, third, or fourth offender. So you can see where that 35 months is where there's no habitual. Second offender, the max is, the high end of the guidelines range is 43 months, goes up to, I can't even read that from here, 52 months, and then for a fourth habitual offender, that cell range, that A1 range, is now 21 to 70. The minimum sentence can be chosen within that range. So the way to look at these ranges is you've got the left, the large number on the left is the min, and the one on the right is the max-min depending on the habitual status. And then, of course, judges can depart below the low end, the min-min, or above the max-min. Overall, the Sentencing Commission's broad mandate included identifying which cases should never result in prison and in which judges should have the discretion to decide whether to impose a prison sentence. But for the life maximum offenses, which virtually always result in prison terms, the Commission itself focused on three goals: preserving judicial discretion, increasing sentence lengths, and making prior record at least equal in importance to offense severity. And for each of those goals, we're going to look at the policy choices that were made and how those choices were implemented and what the consequences were. And this will necessarily just be an overview. It's complicated, but trust me, if you want more details, they're somewhere in here. So, first, preserving judicial discretion. Achieving this was simple. All you had to do was make the cell ranges wide enough, and judges can make very, very different choices while staying within the guidelines. So on the A grid, with a prior record level variable of D, at OV level 6, offense variable 6, am I in the right spot? Right there? The range for a non-habitual is 7 years wide. It goes from 171 as the min-min all the way to 285 months as the max-min. On the murder grid, which you don't have before you, the narrowest range for minimums is 5 years. Ranges of 8, 10, 15 years are common, and the widest in the lower right-hand corner of the murder grid is nearly 20 years. These are hardly substantial constraints on judicial discretion. Thanks to attorney Patricia Streeter, who unfortunately couldn't be here today, but who did an enormous amount of very painstaking work, we have 8 hypothetical cases in the appendix that compare Michigan's scoring to that of 6 other guidelines jurisdictions. In each case, the Michigan range is far wider than the others. This doesn't necessarily mean that Michigan's average sentences are longer. Sentence length is a different issue that's affected by a lot of factors, but it does mean that other guidelines are designed to reduce disparity by giving judges a much narrower range of choices within which to select a sentence. So as a result of Michigan's ranges, there are enormous differences among cases, even when the minimum sentence is within the recommended guidelines range. The next slide looks at where the applicable cell range for non-habitual sentences fell. Nearly 45% between the below the min-min and above it, above the max-min, nearly 45% aren't even within the range because there are primarily so many downward departures. These are all, this graph is all offense types together. So even within these very wide ranges, we see a spread, a widespread across them, and relatively few, very few sentences, median sentences that are actually at the midpoint of the range, even though when the guidelines were developed, the midpoint was thought to be very important. The results are weighted towards the low end because there's a disproportionate share of sentences are for armed robbery, and armed robberies are disproportionately downward departures. But when we look at place on the range for each type of offense, we still find that the sentences spread from below the low end to well above the high end of the applicable cell. So as we can see, if you look at 233 non-habitual sentences that were imposed for sex offenses where the applicable cell range was 135 to 225 months, that's 11.25 years to 18.75 years, a spread of 7.5 years within the range. And 4 cells on the A grid have this range. The sentences that resulted went from 3.5 years to 65 years. The midpoint of the range was 15, but only 39 sentences, fewer than 17%, were right at the midpoint. And even with 7.5 years within which to select a minimum, 19% of the sentences were below the range and 15% were above it. So to reiterate, I mean, these are all CSC sentences which were theoretically in identical cell ranges, and that's the spread you get. So despite the legislature's goal of having similar offenses for similar sentences for similar defendants who were convicted of similar crimes, we see this enormous variation in sentence length for people who were convicted of the same offense and whose guideline scores put them in identical ranges. And as Annie will describe in some detail, these disparate outcomes often relate to systemic factors like the county of conviction, the identity of the sentencing judge, whether it was a plea or a trial. And of course, judges can choose to depart below the low end or above the high end of the range. Both of these slides, this one and the previous one, show that departures, which are essentially a rejection of the guidelines recommendation, play a critical role in sentence length and create that much more disparity. The compliance rate for non-habitual sentences under the legislative guidelines on the murder 2 and A grids together was 55%. A departure rate of 45% means it's not just atypical cases in which departures are occurring. As Kelly said, something's going on when you see departure rates that are that steep. The proportion of downward departures varied from 23% for CSC to 40% for armed robbery. The proportion of upward departures, while quite much lower, varied from 5% to armed robbery to 14% for CSC. Downward departures are rarely appealed. There generally has to be something quite unique about the circumstances for a prosecutor to appeal a below guideline sentence. Upward departures, on the other hand, are appealed by defendants regularly, not surprising. Whether these above guideline sentences are upheld depends in part on the standard of review the appellate courts apply. As I mentioned, the legislature made compliance with the guidelines mandatory by allowing departures only for substantial and compelling reasons. Thus, on appeal, the issue was whether the sentencing judge had a sufficient reason for not selecting a sentence that was within the guidelines. It was guidelines compliance that was being reviewed. But when that portion of the legislation was found unconstitutional by the Michigan Supreme Court in Lockridge, the court chose the solution of making the guidelines advisory, a minimum that is considered but not mandated doesn't violate the Sixth Amendment. So judges must calculate the scores and consider the recommended ranges, but they don't have to follow them. The appellate court only has to find the sentence chosen was reasonable. To be reasonable, a sentence only has to be proportionate to the crime and the defendant. It doesn't matter how it fits with the guidelines. This more relaxed standard allows for a lot of subjectivity and outcomes that are sometimes hard to reconcile, and we examine the impact of standards of review in Chapter 16. The Commission's second goal with these life maximum offenses was to lengthen sentences, and there's no question that that occurred. The median non-habitual sentence increased by 1.5 years, or 23%. The cost of this increase, I think in today's dollars, was $51 million a year, or $720 million for the 14-year study period. The median habitual sentence increased by 5 years, or 50%. The cost of this increase was $35 million a year, or $486 million over the 14 years. So altogether, in today's dollars, the cost of increasing sentence lengths for life maximum offenses was $1.2 billion over 14 years from 1999 to 2012, with no evidence, as Josh will tell you, that longer sentences actually improve public safety. This slide shows us the median minimum sentence length by habitual status for each offense group. By and large, the most significant increases generally occurred as soon as the defendant's status changed from being a non-habitual to a second offender. bear in mind as we look at these numbers, these are just the median sentence, meaning if you made a list of 100 of them, half of them would be above the median and half of them would be below. But it doesn't tell you how much above or how much below. Many sentences actually are over the median, many are under, many are much higher. So these medians are useful for comparisons over time or across groups, but they don't necessarily represent the actual time people are serving. Don't take the median as an indication that, you know, how much people serve on an assault and murder sentence is 11 years. And of course, the habitual sentences are longer in part because they involve people by definition with longer minimum sentences, with longer prior records, I'm sorry. People with higher prior records who weren't habitualized are among the non-habitual group. They may still have long prior records if the prosecutor didn't choose to file an enhancement. But by definition, those in the habitual group have longer prior records. But while habitual, so that's part of why they're longer. But the fact that they were habitualized and the range got wider is the rest of the story. And while habitual offender sentences were much longer than non-habitual sentences, only about a third of the habitual sentences actually exceeded the standard high end of the applicable range. That is, just because judges could take advantage of broadened ranges for habitual sentences doesn't mean they necessarily did. In fact, more than 10% of the habitual sentences at every level were below the min-min. Habitual offender sentences that did exceed the standard max-min ran the gamut from only slightly above to well above even the 100% increase that was allowed. And not surprisingly, the length of the minimum sentence increases from habitual offenses differed by offense type. Another change that may have resulted from the legislature's decision to apply the guidelines to habitual offenders is that the percentage of sentences with habitual offender enhancements increased by 25%. That is, more people are getting habitualized under the legislative guidelines than used to get habitualized under the judicial guidelines. So let's turn now to how these longer sentences were made to happen, regardless of habitual status. First, you increase the starting point of the cells. For example, you take someone being sentenced for armed robbery who is in the highest level for prior record, but the lowest level for offense severity. Under the second judicial guidelines, the range for the minimum sentence was 36 to 120 months. That is 3 to 10 years. Under the legislative guidelines, it became 108 to 180 months, between 9 and 15 years. Then you require judges to score the individual aggravating factors. You require them to score the aggravating factors instead of allowing them to decide on a case-by-case basis whether these factors justify a departure, as typically occurs in other states. And you require them to always score the maximum, the highest possible points. And you don't score mitigating factors. You design the offense and prior record variables to push people into higher offense severity and higher prior record levels. Chapter 6 in the report discusses the scoring of all the OVs and the PRVs in detail. And I'm not going to do that, but I am going to give a few highlights that reflect important policy choices, like double counting. For instance, in homicide and assault with intent to murder cases, OV6, offense variable 6, scores either 25 or 50 points for the intent to kill, even though the intent to kill is already a legal element of these offenses, which put them on the higher grids. OV1 scores aggravated use of a weapon when, although not technically a legal element, that behavior is an overwhelmingly common means of committing murder, assault, and armed robbery. Over 61% of armed robbery sentences had 15 points for pointing a gun at or toward a victim or threatening a victim with a knife, although actual or purported possession of a weapon is an element of the offense. So you have to possess it for it to be armed robbery, but if you point it or threaten somebody with it, there's an additional 15 points. Nearly 75% of murder sentences and 80% of assault with intent to murder sentences had 25 points for discharging a firearm at a victim or for cutting or stabbing a victim. OV2 adds further points for the lethal potential of the weapon, scoring 10 points if it was a short-barreled shotgun or rifle, and 5 if it was a pistol or a rifle or a shotgun. So an armed robbery for which, by definition, the defendant had to be armed goes on the A grid because it's a life max offense, and then gets 20 points for displaying a gun or a knife. Real offense sentencing is something Kelly already described. It's the policy of awarding points based on the real facts of the crime, regardless of what offense the defendant was actually convicted of. So, for instance, if our armed robber, who we'll call Sam, pled down to unarmed robbery, he'd still be scored under OVs 1 and 2 for using a gun. OV12 scores felonious conduct not resulting in conviction that occurred within 24 hours of the sentencing offense. Using the policy of real offense sentencing, the sentence for the conviction offense can be increased based on uncharged conduct or charges that were dismissed in plea negotiations. So, for instance, if Sam hit a clerk and locked her in a back room, he could be charged, in addition to robbery, with kidnapping and assault. If those charges were dismissed in plea negotiations and he just pled to robbery, he would receive 10 points for the 2 additional crimes. OV13 combines double counting and real offense sentencing. Among other things, it awards 25 points for a pattern of felonious activity involving 3 or more crimes against a person within a 5-year period. It doesn't matter whether the offenses resulted in convictions. The offense for which the defendant is currently being sentenced must be counted, although crimes scored under OV12 can't be counted. It gets complicated. But for instance, assume that Sam had gotten into a bar fight 4 years earlier, before the robbery, and been charged with 2 counts of felonious assault. He hit somebody with a chair or a bottle. 2 people. He pled guilty to 1 count of felonious assault and got probation. The other count was dismissed. It was not a big deal felony. But added to the current robbery conviction, he would have 3 offenses against a person in 5 years and would receive 25 additional points. And again, if you keep your eye on the grid, you can see what the impact is of those 25 additional points and how it helps push you along. Still, another example of real offense sentencing is actually a prior record variable. PRV 7 awards 20 points for 2 or more subsequent or concurrent felony convictions. If Sam went to trial and was convicted of robbery, kidnapping, and assault, even though all the sentences would be served concurrently, they could all be lengthened based on these additional 20 points. That is, prior record variable 7 allows for punishment for the sentencing offense to be increased on the basis of convictions that would not otherwise count. Overall, 47% of sentences were pushed into at least PRV level 7 based on this single variable. In addition, concurrent and subsequent convictions that are scored in PRV 7 can also be scored as part of a continuing pattern of criminal behavior under OV 13. So that's how they get double counted. With only 20 points separating each of the 6 offense severity levels on the A grid and 50 points separating the 3 offense levels on the murder 2 grid, the offense variable scoring results in people easily reaching the 100-point cutoff for the highest level on either grid. Third, the Commission chose to make prior record at least equal in importance to offense severity. And we can see from the way the grids are designed, there is this constant balance being struck between PRV level and OV level. So if one goes up, the other goes down. The cell ranges stay the same. As a result, the murder 2 grid has 18 cells, but only 8 different cell ranges. The A2 grid has 36 cells, but only 11 different ranges. The guidelines create the illusion of precision, but in fact, all these redundant cells yield median sentences that are inconsistent and unpredictable. Over and over again, identical ranges produce widely different median sentences. So we also see median sentences that are below the mid-min of the cell, median sentences that are at the mid-min of the cell, different ranges that have identical min-mins, and identical ranges with very different min-mins. Medians. Different ranges with identical medians and identical ranges with very different medians. And in particular, the same ranges result in very different median sentences depending on the offense. So if a CSC falls in the same range as a robbery, the medians are going to be real different, no matter what the cell ranges actually say. The A grid has 6 cells with a range of 108 to 180 months. These run on the diagonal from the A4, from the A6, down in the corner, up to the F1 in the upper right. This slide shows the median sentences for each of these cells, depending on the type of the offense. So while each offense starts with a median, again, these are the 108 to 180 month cells. While each offense starts with a median of 120 months in the A6 cell in the lower left, they exhibit very different patterns as they go along the diagonal towards the F1 in the upper right. You can see the CSC, which is the orange, rise, then fall, then rise a lot. The assault medians mostly fall. The robbery medians blip down, then go back up, but then stay completely flat. In the B5 cell, if you look straight up, the difference in median sentences is nearly 5 years. In the E2 cell, the difference, depending on offense, is more than 7 years. The scoring of the 7 prior record variables is designed to move people into higher prior record levels with relative ease. There's a decay factor that helps eliminate very old priors. Prior convictions can't be counted if they're more than 10 years, if more than 10 years have elapsed between discharge from that offense and the commission of any subsequent offense. But there's this chaining effect, so that if you were convicted of offense A 20 years ago, you were discharged from parole 9 years ago, but then committed offense B, priors A and B will both be scored when you're sentenced now for offense C. The scoring of prior felonies distinguishes between high severity and low severity felonies, a sensible and common technique, with far fewer points awarded for low severity felonies. For high severity felony, 1 prior adds 25 points and immediately pushes you into prior record level D. 2 prior high severities, gives you 50 points and pushes you into PRV level E. And 3 priors are 75 points and push you right into level F, regardless of what else your prior record looks like. The trick, however, is how high severity priors are defined. Michigan treats any prior that carries a maximum sentence over 5 years as high severity. This makes the most common high severity priors possession of meth, delivery of narcotics under 50 grams, assault with intent to commit great bodily harm, breaking and entering into a commercial structure, and uttering and publishing. So these are the high severity felonies that are driving a lot of people into higher prior record levels. And in scoring the priors, whether high or low, you count multiple convictions from the same incident. So if somebody had 3 prior convictions because they had 3 victims in a robbery, or 3 crimes were committed in the course of 1 transaction, you stole a car while in possession of drugs and then fled from the police, those are 3 priors. Since prior record level depends on the total number of points, regardless of how they're accumulated, it is quite possible for a defendant to score into prior record level E without any prior convictions more serious than one with a 5-year max. This can result from a combination of low severity felonies, juvenile adjudications, misdemeanors, and the scoring of other factors that aren't even actually priors. In turn, a high prior PRV level then can push defendants with relatively low offense severity scores into high guideline cells, adding years to the low end of the recommended range. We already saw how prior record variable 7 counts concurrent and even subsequent convictions. Prior record variable 5 scores misdemeanors. Any adult misdemeanor or equivalent juvenile adjudication that's an offense against a person or property, a controlled substance, or a weapons offense, or involves operating a vehicle of any kind while under the influence gets scored. One misdemeanor is only 2 points, but that immediately pushes you into PRV level B. 2 misdemeanors is 5 points. You get up to 20 points for 7 misdemeanors. But because of the way old priors get counted, if you had 3 misdemeanors 9 years apart, in 27 years, you'd get 10 points, and it'd put you right into level C. PRV 6 scores points for the defendant's relationship to the criminal justice system when the sentencing offense was committed. So, for instance, if you were on probation for a misdemeanor, here's 5 points under PRV 6. If you were on probation or parole for a felony, that's 10 points. If you were in jail, pre-adjudication or pre-sentencing, and you did something while you were in that amounted to a felony, that's 15 points. If you were in prison, if you were in jail or prison, but you'd already been sentenced, that's 20 points. So, in effect, serving a jail sentence for a misdemeanor and catching a new conviction is the equivalent of 3 prior low-severity felony convictions. The common thread in PRV 6 is extra punishment for not having been deterred by past punishments. However, every relationship to the criminal justice system already carries its own punishment in the form of parole or probation revocation or consecutive sentencing. These added points are on top of penalties that are built in when you commit an offense while you're in jail or while you're on parole or while you're in prison. So this is another clear example of multiple punishments for the same facts. Take a defendant who's being sentenced for being a prisoner in possession of a cell phone. That in itself has a 5-year max. She's going to receive, under PRV 6, 20 points for being in prison when the offense was committed. Another 25 points under offense variable 19, which is a threat to the security of a penal institution, which is how cell phones are viewed. And by statute, the new sentence will be consecutive to the one she's already in prison serving. Then there's the ultimate double counting of prior record, which is increasing the high end of the cell range because the prosecution has chosen to file an habitual offender enhancement. The habitual offender statute allows a judge to increase the maximum sentence beyond what is set by the penal code for the conviction offense. So if the statute carries a 20-year max, the judge can actually go above it if somebody's habitualized. If the conviction offense already carries a penalty of life or any term, the habitual offender statute can't make the potential maximum any harsher than life or any term. But by leveraging the defendant's habitual status to raise the guidelines recommendation for the minimum sentence, defendants convicted of life maximum offenses may also have their prison terms lengthened by the prosecutor's decision to pursue habitual offender charges. There's no limit on the age, nature, or severity of the prior felonies that can be used to support an habitual offender enhancement. The prior convictions don't even have to arise from separate criminal incidents. The defendant's criminal history is already a key component of the sentencing guidelines. The higher the prior record score, the higher the guidelines range. Why then should that range be expanded based on the very same consideration, the defendant's criminal history? This use of the habitual offender enhancement does not just double count the defendant's prior record in a general way. It has multiple specific consequences. Most apparent, it allows for such enormously long minimum sentences and such enormously wide guidelines ranges that it effectively negates any constraints on judicial discretion in sentencing people as habitual offenders. Equally important, the habitual enhancement and the PRV score can count exactly the same prior crimes. That is, the same priors can put the defendant into a higher range in the first place and then be used to raise the high end of that range because you've been habitualized. Conversely, the habitual enhancement can be used to increase a minimum sentence based on priors that the sentencing guidelines weigh less heavily or exclude altogether, if they're too old, for instance. Since filing habitual offender enhancements lies solely in the prosecutor's discretion, widely divergent practices occur across counties. And this adds to the disparities in sentencing the guidelines that the guidelines were meant to reduce. As Kelly's colleagues at the Robina Institute have warned us in several of their very thorough publications, criminal history enhancements can have a number of adverse impacts. They can increase the size and expense of the prison population. They can shift the age, composition, and risk level of prison inmates who are older and nonviolent individuals tend to have longer criminal histories. So if they're habitualized, you've got a population that's older and nonviolent. They can undercut the goal of using limited prison beds for people who are actually convicted of violent offenses. They can decrease the proportionality of sentence severity relative to offense severity. So the more you put emphasis on prior record by habitualizing people, the more weight you're giving to prior record, the less the sentence depends on the seriousness of the offense itself. And finally, and importantly, they can increase racial disparity in prison populations because non-white defendants have larger criminal history scores than whites. Thus, as Annie will explain, there's very little evidence of overt racial discrimination at the sentencing stage itself. But the myriad factors within and outside of the criminal justice system lead to non-white defendants having more juvenile adjudications and more felony convictions, and that results in larger prior record scores. These, in turn, contribute to the massive imbalance of Black and brown people in our prisons. To summarize, which I really am right now, in adopting the Sentencing Commission's guidelines, the legislature made numerous critical choices. It opted to group offenses on grids by their statutory maximum sentences instead of by the similarity of the defendant's conduct, although judges and prosecutors generally think about crimes by the nature and extent of the harm they cause. It included numerous redundant cells in an attempt to balance the weight given to prior record and offense severity scores. It made the ranges on the grids that apply to life maximum offenses extremely broad in order to preserve judicial discretion. It designed prior record and offense severity variables that double count aspects of the conviction offense and of the defendant's criminal history, that score behavior that was not part of the conviction offense, and that purposefully enhanced sentence lengths for murder, assault, and CSC cases. It incorporated numerous aggravating factors into guidelines variables, then required judges to award the maximum number of points available for those factors. It declined to incorporate mitigating factors into the variables. It extended the high end of the guidelines range for second, third, and fourth habitual offender sentences by 25, 50, and 100%. And it made compliance with the guidelines mandatory but permitted departures for substantial and compelling reasons. It was expected that the Commission would have the opportunity to assess the impact of these choices and to recommend changes as needed to better achieve the guidelines' goals. Because the Commission was abolished, that assessment never occurred. While the analyses in these chapters are no substitute for a systematic review by a multi-stakeholder, professionally staffed commission, the evidence we've examined suggests several conclusions. The guidelines don't compel extremely long sentences, but they allow and encourage them. Judges routinely imposed minimum sentences at or below the low end of the ranges. especially in armed robbery cases, even when the defendant had received a habitual enhancement. Judges and prosecutors often behaved as if they felt the guidelines recommendations were inappropriately harsh. However, judges also commonly imposed minimum terms of 25 or more years, especially on those convicted of murder, sex offenses, and as habitual offenders, while staying in compliance with the guidelines. The extent of departures from the recommended ranges suggests that judges were frequently dissatisfied with the options they were given. The complexity of the guidelines creates the appearance of precision while preserving enormous discretion for judges and enhancing the ability of prosecutors to achieve outcomes they desire. The guidelines not only failed to reduce disparity, they promote it. Thank you for your patience.